Hi everyone, Alan here from Communication and Conflict, promoting mindful communication, growth through conflict. So this video is also a podcast on anchor.fm under the name Chaos, which is my business, the name of my business in London. So today I want to talk about alternative dispute resolution and hopefully try to kind of clarify some of the misconceptions that can sometimes happen about what alternative dispute resolution is. Um, uh, Originally, as I understand it, alternative dispute resolution was meant to mean an alternative to going to court as a dispute resolution option for reasons that could be many. It could be just on a basis of cost, on the basis of the severity of the situation. It may not be the kind of thing that needs a court. It just needs there to be some kind of evaluation of the relevant strengths and weaknesses of different cases being made about a dispute situation. And so in all of those contexts, the process is still presumed to be an adversarial process where perhaps someone is making a complaint against somebody else or is making a claim of some kind, and it goes to arbitration, such that there's an arbitrator who makes a decision about, with reference to certain laws or regulations or kind of guidance, whichever is appropriate to the situation, makes reference to those and gives an assessment of what the outcome of that hearing should be. So it's the arbitrator is the third person who gives a view about the situation, just as a judge will do or a jury will do in a court situation, based on hearing the respective arguments. Also, adjudication is similar to that. It's that there's an adjudicator. There are various kind of slightly different legal aspects to those two processes, but effectively they're both about going to a third party to give a view about two respective positions being presented, and to give a view about which one is right and which one's wrong, or which one's more in favour and which one's less in favour with regard to certain issues or claims. As I say, for me though, the significant thing is that there's a third party who's giving a view, whether it's in court or whether it's in these alternatives to court, such as arbitration and adjudication. Now, the thing is that mediation also comes under the heading of alternative dispute resolution, but mediation is in itself a very different alternative to how conflicts and disputes can be responded to, because the point about mediation is that the third party, the mediator, does not give a view, and that changes the whole dynamic of the situation. Because when the third party does give a view, such as in a court or in arbitration or adjudication, then the two parties have to make their strongest case to that third party to persuade them that the other one's wrong and they're right, or their argument is stronger and the other one's is weaker. And obviously that happens from both sides. So it's intrinsically an adversarial process. One's trying to win and the other one, such that the other one loses, and vice versa. So it's intrinsically adversarial. The point about mediation is that it's intrinsically collaborative and cooperative, even if the parties hate each other's guts. The point being that they're working together to create an outcome that works best for both of them, because they're not continuously making presentations to a third party in the hope that that third party will find in their favour. So because that's absent, it means the parties can only be working together on an outcome. So therefore they're going to create something together which is in both of their interests, and they'll have to take into account each other's concerns and viewpoints and needs in the situation, and their the factors that are affecting their decision making about how to go forward, etc. They have to engage with each other to hear each other's point of view, so that then they can create a way forward together, because that's not going to be decided on their behalf by the third party mediator, which is what happens in arbitration and adjudication and in the court. The decision about how things should go forward is handed over to that third party. Now, in many dispute situations, mediation in some senses is the only realistic option that's going to work for people, because and vice versa, in some situations mediation isn't going to work for people, because it's going to be very clearly an issue of legislation or law being broken. So it's important to know the distinctions of where between the two, about where each one is applicable and where it's not. So mediation is particularly applicable where there aren't clear objective criteria by which to assess who is in the right and who is in the wrong. So therefore, when the law is involved, if someone's hit someone, that's breaking the law of assault. So therefore, if there's evidence to prove that it's happened, it's right and proper that that should go through an adversarial process such as the courts to decide what the punishment is, what the outcome should be that's imposed upon that person who's carried out that act. But in situations such as neighbour disputes, family disputes, workplace disputes, where it's not the case that someone has actually been broken the law, and as you've seen in some of my other videos, perhaps the idea of bullying is not something that is a legal issue, even though a lot of people make complaints about bullying. It's most appropriately responded to through mediation, because there aren't objective criteria by which to assess whether bullying has occurred, and yet so often it is responded to as if there are, and so people are always disappointed, and I mean almost always disappointed. I mean, we're talking really, really small number of situations where there ever is a conclusive outcome into bullying investigations, and that's because it's not the kind of thing which is suitable for an adversarial process. If it was something like harassment, where there can be evidence, then obviously that's a legally defined form of abuse, and so therefore you can get evidence. But bullying, you can't. And similarly in things like neighbour disputes as well, where people have fallen out over things like noise or parking issues or boundary issues, very often there is not going to be a clear legal breach in some way. There might be things that there's guidance on, but it will be very unlikely that you can actually prove that someone's broken the law. And so in many neighbour disputes, it's more appropriate to try to resolve it through mediation rather than take people to court. I mean, we'll often hear of cases going to court over neighbour disputes over things like fences or hedges or whatever, and people can go to court time after time after time without getting a clear outcome, and spend tens of thousands of pounds and still not get a clear outcome that anybody's really happy with. And that's because it's almost certainly not an appropriate thing to go through court. It doesn't mean to say people can't still pursue a court option. They always have that right, but the likelihood of a clear outcome is it's very small, let's put it that way. It's not for me to put figures on it, but it's very small. So therefore that's why mediation is appropriate. Similarly for family disputes, again, unless somebody's done something illegal like assault, it's very unlikely to be something that goes to court, but there is still this ongoing family dispute, just as there might be an ongoing workplace dispute, an ongoing neighbour dispute. And mediation is a means through which the people involved can create a better way forward by themselves, because no one's going to be able to come up with an outside imposed solution to their relationship difficulty. Now that's a concern for a lot of people, because they kind of find it difficult to think of trying to resolve it with this other person, their dispute with this other person. But it's also about looking at the reality of there being a likelihood of resolution by any other means. So many people do try adversarial processes in the hope that they will get a finding in their favour, but unless it really is, unless there's some kind of legislation or law that has been broken and can be proven to have been broken, it isn't really ever going to be resolved through the law. And so therefore it's important to understand the why mediation is an alternative, but it's an alternative that's very different to other processes, such as arbitration, adjudication, and going to court. So, and I think one of the reasons that's kind of prompted me to talk about this is that unfortunately the term mediation is starting to be used in ways which I think confuse the issue for a lot of people, because it's being used in situations where it's not really mediation in the sense that I've just described. It's still taking a view, it's still having an input to a dispute. But it seems to be that simply because mediation's become an expected part of the legal process in the last 10 to 15 years, or more significantly, I think it was always present to a small extent, but it's much more significantly in the last 10 to 15 years, particularly in divorce situations, for example, and possibly in contractual disputes. But in a lot of contractual disputes, the term is being used in a way which is in many ways still adversarial. And so there's starting to be confusion about what it actually means. So, for example, the other day I heard of someone going through an employment tribunal, and they were asked to, or offered the chance to meet with a mediating judge before going into the formal hearing. And when I heard that, I thought, well, what's a mediating judge? Because that's kind of a contradiction in terms. A mediator doesn't judge anything or give a view about anything. And what it turned out to be was that this person who's had experience of working in the law would give a view about the respective strengths and weaknesses of each party's case, so that they could decide whether they want to settle out of court and to have an understanding of what the likelihood would be of them winning their case if it did go to the formal hearing. Now the thing is, that's not really mediation. Well, it's not in any sense mediation. It's what used to be called neutral evaluation, where the person is neutral, they don't have any involvement in the case, but they're just giving an evaluation of each party's case or position. So there are times when things that always have existed, but used to exist under different names, are now being called mediation. And it's very different to mediation. It's not mediation in any sense at all, really. Things that used to be called settlement conferences in kind of contractual disputes or compensation disputes are now sometimes being called mediation. But a settlement conference is a negotiation. It's a different thing. Negotiations are still, to a large extent, an adversarial process. Not necessarily because there's a third party giving a view, but it is about winning against the other party to try to get the best outcome, almost irrespective of what the concerns are of the other party. And that wouldn't happen in mediation, because in mediation you have to engage with the concerns and needs of the other party, because otherwise you're not going to be able to create a way forward. But in negotiation it doesn't matter. You either get what you want or as close as possible, and therefore you deem yourself to have won, and it doesn't matter whether the other person's lost or not, because there's no kind of subsequent consequence to it other than that you've got a lot and they haven't got that much, or vice versa, you haven't got very much and they've got a lot. So it still feels like a win or lose situation, whereas in mediation it's in the interest of both of you to create something that works for both of you, so that the problem doesn't exist anymore. But settlement conferences are being called mediation, and often that's because mediation within the court environment is often a situation where a disputant is represented by their solicitor and their lawyer. Now, solicitors and lawyers operate an adversarial process, So therefore, when it's handed over to them to kind of debate the potential outcomes of a case, it's almost inevitable that it's going to still remain an adversarial discussion rather than a mediated discussion. They're not going to work together. They're going to work to get the best outcome for their client in terms of what the law says or in terms of what the financial possibilities are. And yet it's still being called mediation. So there's a lot of confusion around the use of the word mediation, partly because mediation has become something that's being expected within some legal processes, but unfortunately because of the way that mediation is positioned within those legal processes, what's tended to happen is things that used to happen anyway are now being called mediation just so that it can be said, yes, we're doing mediation. But really, in contrast to what mediation is actually like, as something that doesn't really fit within the legal process strictly, what actually the way in which it's carried out is very different to the way that mediation, for example, is carried out in community situations, like in workplace disputes, like in neighbour disputes, like in family disputes, like in complaints. So just quickly to add about complaints, complaints are often unresolved because an organisation that's complained against will have perhaps carried out their complaints process and not found there to be any basis for concern according to their complaints process, but the person who's made the complaint is still upset. But that's because they're having the outcome defined by the organisation that they're complaining against. So therefore it's understandable that they may not see that as a fair thing to happen. So they continue to complain even though they're told there is no complaint to answer. So sometimes mediation can be really helpful in that situation because it enables there to be a resolution created by the organisation and their representatives and the person complaining, which doesn't require there to be any breach of their complaints procedure, but still acknowledges that the person is unhappy. So therefore, in a sense, it's in both their interests to try to come to a resolution, because the fact that the complaint's continuing is still a cost and something very difficult for the organisation, and it's still not to the satisfaction of the person complaining. So mediation can be used in that kind of situation as well. But it's important that no view is given, because it's not the kind of context in which you can give an official view, because there's no objective basis on which to do it. So that's just a little kind of scan through of the different things that can be a confusion in the alternative dispute resolution field. I hope it didn't confuse you more, but I wanted to try to really emphasize the difference between mediation and other processes, because most other processes, all in fact other processes, are adversarial, and mediation's not intrinsically, because the mediator doesn't give a view. So if mediation ever happens where the mediator does give a view, it's not really mediation. It's a very different process, because that third party has such an influence on the situation that by giving a view, that it means the parties focus on that person and persuading them rather than working together, because it's only their views that matter in that situation. The third person's view doesn't influence what they create, it just supports them in moving towards that creation. So it's an important distinction to make, so that people can be clear about what to expect from mediation as opposed to the adversarial processes, and both have their place. Mediation is very appropriate for some situations, adversarial processes are very appropriate for others. They're not trying to take each other over, although sometimes there's a portrayal of mediation as if it's trying to take over adversarial processes. It never can, and it never will, if it's understood properly. But where there's attempts to try to kind of merge the two, it always defaults to being an adversarial process. And if you really kind of think through, it can't but move in that direction, because the second the third person, the third party involved gives a view, it's intrinsically adversarial. So I hope that's helped to clarify some of the things. I hope it hasn't confused you instead. If there are further questions that you have, please pop them in the comments section below. or just get in touch with me via the podcast. If you like the video, if you think other people might be interested to hear it, please share it with them. Please press the like button if you did like it. Please subscribe to the channel if you'd like to hear more about mediation and related communication and conflict related issues. Thanks very much for watching. Bye bye.